All right.
Hearing in review, Allison and Majesty's advocate.
Mr. Jackson, we're proposing to hear Allison first. I hope that's convenient to everybody. And what we'll do is we'll hear the entire argument in Allison, and then that having been completed, we'll pass on to McInnes. And I suggested that counsel who are in Allison's case should be in the front row, and for obvious reasons, McInnes in the row behind. Yes, it seems to be a very large measure of agreement between you and the Lord Advocate.
Very much so. Really, as far as the law is concerned, almost no disagreement at all.
Well, there are two basic points. I would have thought the first was whether there was a failure to disclose material which should have been disclosed, and that's accepted, that the outstanding charges should have been disclosed. And I think it's accepted that the court below went too far in just dismissing the outstanding charges as something which could not possibly have any importance. And then there's a question whether there's a devolution issue, and that's accepted, Mr. Prentice, I think, isn't it? And so there we are, and the question really is disposal, isn't it? That's what we do next. Is that what the case comes to?
What I do next is turn over 4 pages of my
notes. Before you do, I mean, I know it's really largely agreed, but how would you exactly, I mean, I think there's some question as to exactly what the relevance of outstanding charges are and so on. I think how one would put the test. Or
I would not put the test any differently than my Lord Rodger has outlined in the case of MacDonald.
Should we look at the case then, just to see exactly what the proposition is?
Because that, in my submission, sums it up, if I may say so, fairly well. And that is at tab 10 in the volume of authorities and paragraph 50.
Yeah, is this a joint volume, a single volume?
Yes, but just a single volume of authority.
Yes.
paragraph, what did you say, 50?
50, 50. And reading just at the top of the page into paragraph 50, as the appeal court pointed out in the present case, in these decisions the judges use slightly different expressions to describe the nature of the material that has to be disclosed. I do not regard those verbal variations as being of any significance. I would respectfully agree with that. I tried to list all the ways that the test has been described. Sometimes it's a risk of real prejudice. It's described in a host of ways. But I would agree with the statement that these different ways of putting it all come to the same thing. And my Lord goes on to say all the expressions are designed to describe the same obligation. The golden rule, quote, described by Lord Bingham of Cornhill in RVH&C, has the advantage of encapsulating both the possible negative effects of material on the Crown's case and its possible positive effect on the defence case. Put shortly, the Crown must disclose any statement or other material of which they are aware and which either materially weakens the Crown case or materially strengthens the defence case. Now, with respect, I can't find a better way of putting it than that.
It's nice of you to say so, Mr. Jackson, but I was really getting a slightly different. I mean, supposing you got this material, the outstanding charge. I mean, what can you do? What exactly can you do? Because I think that's raised a little bit in the.
I'm not sure what my Lord means by what could I do with it. I can certainly answer why I think it was important, why it was material.
That's probably the same point.
The reason I was distinguishing there is the question is raised as to how one deals with it.
Yeah.
But I take the view, although there's no direct case this has happened, if you're dealing with, as it were, a dead witness, then you couldn't put the previous convictions to that witness. But nevertheless, it would be relevant to bring them out in certain circumstances, so you would just by some other method, an extract conviction or whatever, you would place before the jury he had those convictions.
Well, what would the relevance be? See, the way the court put it in paragraph 20,
Yes.
the judgment, which we have in the bound volume.
Yes, I understand. Yeah.
Paragraph 20, Lord Osborne, I think, is making the point that where an individual is charged with a crime, he's innocent until he's proved guilty.
Yes.
He says, and therefore you can't assume, obviously, from the fact there are outstanding charges that he's guilty of.
But that, I suppose, is their argument for saying that outstanding charges are not material which should be disclosed. But we have, I think, got past that in that this court has decided in a number of cases, and that's what we're in agreement on, and that's where my Lord began with me, that outstanding cases should be disclosed.
Yes, but the point remains exactly what you do with them.
What value would they have?
Yes, exactly.
Well,
that's, I think, what my Lord
I would answer that by that needs to be applied to the facts and circumstances of a particular case. One can imagine various ways in which they might matter. For example, they could provide a motive for someone cooperating with the police. That would not be an uncommon situation, where someone with outstanding charges is of the view that if they cooperate with the police, or as it were, give someone else up, then it might go in their favour at some later proceedings. It also can simply go to the question as to whether or not this is a person that one can properly and easily rely on as a truthful, credible witness. So to use the old cliche, it goes to credibility. In general terms, it goes to credibility. But in more particular terms, in some cases, it might be demonstrating the motive. So the question as to whether or not it matters has to be looked at. Does it matter in that particular case?
I mean,
and that's always the difficulty.
Yeah, I mean, if one were dealing with someone just in a private capacity, one's attitude to him or her might change if one knew that there was an outstanding charge of fraud against him or her, even if it hadn't been yet proved. You would take it into account.
You wouldn't still buy the used car,
no,
even although they were innocent technically of the crime.
You would certainly think twice.
You would certainly do that. And the only real difference, I think, if I've got this right, between myself and the Advocate Depute in this case, is how it mattered in the present case. Because we both say that it should have been disclosed. We are both content with the test, which I've mentioned in paragraph 50 of MacDonald, which is repeated, I think, by both my Lord Rodger and my Lord in the Chair, in the case of murder. No one is, in this argument at least, I can't speak for other cases, but no one in this argument is disputing the test. And therefore the only matter which is between us is whether or not in the circumstances of this case it would have mattered.
There is a helpful discussion in the case for the respondent in paragraph 14.
Yes.
And I think it's useful to know whether you agree with the way Mr. Prentice puts it there. This is where in paragraph 14 of the respondent's case, he says the Crown doesn't resist the proposition that an outstanding charge of the Crown witness might be capable of materially weakening the Crown case. And the example he's given is if the witness and this is assuming a live witness, of course,
Yeah.
to deny he'd ever been in trouble with the police.
Yes.
Which is a point that one might
Indeed.
quite naturally put to a witness.
Indeed.
And that one could see that would be relevant there, that he's got to the point of being charged.
Which is why I say that one has to start with, it is disclosable. The test is what I may shorthand as a materiality test, and then you simply have to apply it to the particular case, because it could be a huge variety of ways it could be applied to different cases.
Yeah.
And then the motive one is mentioned, but also the idea that the witness might have a personal animus against somebody, because presumably the charge would either be some detail given as to what the charge was.
Yeah.
And, it would be based upon an allegation by somebody.
Without being anecdotal, there is a case due to come back to the appeal court in Scotland on precisely that point, where a key witness, it has now been discovered, had an outstanding charge, and the witness against him on the outstanding charge is the person he gave evidence against in the trial. Now, that case is in the pipeline to come back as a reference from the Scottish Criminal Cases Review Commission. So it gives a perfect example, if I may say so, of that happening.
Yeah. And in Holland, they had the outstanding charge related to drug dealing from the very premises which were involved. And so
But one
These are
cannot
just
say how it matters. One has to say how it matters in a particular case. One simply has to take the materiality test and then say, as a matter of judgment, because in the end of the day, these things are always a matter of judgment, how does it apply to the particular case? And I say in this case, because this is the only area we're in disagreement on, so I move to that in this case, it does matter.
Mr. Jackson, I mean, in a way, if it's already agreed that these outstanding charges fell within Lord Hope's definition of what was disclosable in MacDonald,
Yeah.
I mean, the past has almost been sold, hasn't it? Because the obligation is to disclose these sort of things. If they do materially weaken the Crown's case or materially strengthen the defence case, and if they do either of those things, almost by definition, if it's material.
That's right.
But I mean, that's not quite what's agreed here. What's agreed here is that they might be capable of materially weakening the Crown's case.
Oh yes, that's where we are in disagreement. If we were in agreement on the final point, there would be nothing to argue
Well,
at
quite,
all.
but I'm just suggesting that therefore I mean, you actually have to, I mean, the question is whether they should have been disclosed, not whether their disclosure would have made any difference, strictly.
Well,
I mean, I thought we agreed in the later case of Murtaugh that actually, just to be on the safe side, you would disclose these things anyway.
I don't think the Crown are in disagreement with that. I think we are in agreement they should have been disclosed.
I know, but not because they met that test, because that test goes too far, if that's what's...
it should really be which may either materially.
Exactly.
I mean, that would be best. That would refine it.
Yes.
And I think that would be preferable, for the reason Lord Brown says.
But what I think, I don't want to speak for the Advocate Deputy, but what the Crown, I think, are saying, in this case, that is all curable at this stage, in the sense that when you look at it, you would say, well, it's not material.
Right.
In the same way as, rightly or wrongly, the appeal court in Scotland cured, if I may use that word, the lack of disclosure of the previous convictions. The Crown are inviting you to do the same with the outstanding cases and say, in lay terms, they didn't matter all that much.
Well, the way it's put, and I'm sorry to keep referring to Mr. Prentice's case, but it's a useful
I intend to do that.
text to use. Page 12 in his case, letter F, he's saying that, in effect, in this case, the outstanding charges could not properly have been deployed, and no unfairness was caused. And he's got, I think, 7 points that he makes in order to reach that conclusion.
And what I had
the issue between you.
And what I had intended to do in presenting to this court why it does matter was, in fact, to use the Advocate Depute's 7 reasons as to why it didn't matter and to answer each and every one of them.
Well, shall we proceed then?
And that, I think, is the only matter in dispute, answering those 7 points. The Advocate Depute says, first of all, it was part of a circumstantial case against the appellant and was not of such significance as to be decisive.
Mr. Jackson, I would just so I clear my mind, what we're considering is what additional it would come from disclosing the outstanding charge.
Why it would have mattered.
Why that, given that we have to assume that it didn't make enough difference that they hadn't disclosed the previous conviction.
Well, I'm stuck with that. I
Yeah,
might
that's
not
what I mean.
like it,
There you
and
are,
I might
stuck.
not agree with it, and I will have to deal with that. That's one of the 7 points.
Yeah.
But I accept to a degree I'm stuck with that.
You accept that, do you? I mean, why aren't you suggesting that really what we should be considering is the cumulative failure?
Well, see, my lord, I may say is ahead of me. That is what I would have said. It is the cumulative failure. What I meant, I am stuck with it.
I'm not suggesting, incidentally, don't get too optimistic. But I'm just trying to see how you should be putting it, at least.
No. The cumulative point was the point I was going to make. When I said I was stuck with it, I meant I'm stuck with what they did. But my answer to it
If you add this bit,
is
then
the
it tips it
cumulative.
over. Yeah.
Absolutely. It is what I will call, but I'm jumping ahead, the tipping point. But they say, the advocate answers in a number of ways. He says, first of all, it was part of a circumstantial case and was not of such significance as to be decisive. Now, I would say that in a sense is true.
True.
In a sense, in that it was a circumstantial case. And that circumstantial case, I don't intend to go through it in detail, but is laid out in a number of places in the volume. In particular, you would find it in the judgment in Allison at tab 10 and paragraph 16. It's also in the judge's report, which is at tab 4.
You've got the right... Oh, sorry, there are 2 paragraph 16s in the judge's...
Oh, I'm sorry, I didn't realise it.
It's the first one, headed under the heading of the decision. Is that right?
Where's the other? Oh, there are 2 16s and 17s and 18s. Oh, no, wait a minute.
Oh, so something... Oh, sorry, it's a quotation.
No, it's a quotation. The second is a
I'm at
quotation.
paragraph
yeah.
16, where the words "the decision" appear before the paragraph number.
No, it's my mistake. It's 16 is a quotation from Lord Hamilton's.
Yeah, that's right.
All right.
I think the supplementary report, Lord Brackeydale's at tab 8.
Yes, that does it too. I've marked that as the other
tab
way of
8,
doing it.
not 4.
It's laid out in a
Where is
number
it?
of different
Tab 8.
places.
I know, but
And
which bit?
I'm content to say that that is the better place to do it from.
It gives a great deal of... But it's actually, yes.
It's
good
tab
in-
8 and it's in his third report.
Third
if I may
report
call
is
it
the one
that.
which goes into it in detail.
Yeah.
It's the one that's got all the writing on it, I think.
But that is the circumstantial case. But could I, without going through it in detail, just say 1 or 2 things about that to make the point I want to make?
Read your papers in advance, Bob. Towards the back. Towards the back.
What was that? Where's the bit that you want? Okay, all right. Okay. I've got it on there.
That's the one.
So it's the third report we're looking at.
Sorry, my lord.
There are three reports, I think, collected in tab 8. I think
Yeah, it's the third one. I think the passage being referred to is in the third report.
Yeah.
But about the circumstantial case, what I would say is this, and this is, in my submission, the important point. The evidence that Stronach gave via his statement, the evidence which came from, as it were, the dead Stronach, was of a different character than all the other pieces of circumstantial evidence. It was not just a piece of circumstantial evidence like any other. By that I mean, it was the only piece of circumstantial evidence that directly linked the accused Allison to a drug transaction.
It was the only bit of direct evidence.
It was directly linked to a drugs transaction. Everything else linked him to people who were involved in the drug business. It was every piece of circumstantial evidence involved him with meeting people. It was his evidence of association with people who in turn were involved in the drug business.
Are you referring to the bottom of page 3 of this report?
Indeed,
He
indeed,
mentions him by name.
indeed. But what Stronach was saying was that on the day he had driven a car to Ayrshire and had been stopped with £30,000 worth of illegal drug in his car, he was on that day driving on the instruction of a man whom the jury could infer was Mr. Allison. So it was not a piece of evidence like any other. It had a particular significance. And although this is not in the documents you have, it is not without note, because I checked it just recently, that in dealing with this in his speech to the jury, the Advocate Depute described that piece of evidence as being significant. In that sense, he did give it some prominence, because he speaks about, and I quote, Mr. Stronach said that it was Stevie who asked him to take the car down to Kilmarnock. Now, if that is true, that is clearly a, quote, significant piece of evidence, because it would closely associate Stephen Allison with a specific vehicle on a specific day, a specific vehicle that you know was found later that same specific day to contain a substantial quantity of cocaine. So the Advocate Depute was, to some degree, and quite properly, majoring on the fact that that linked him directly to a drug transaction. Everything else is just association with people who are in the drug business. So when the Advocate Depute says it is part of a circumstantial case, he's right. When he says it was not of such significance as to be decisive, if he means by that, was there a sufficiency of evidence without it, then he may be right. But it should not be thought it was just a piece of circumstantial evidence like any other. It was a highly significant piece of circumstantial evidence, because it was, as I repeat, the only direct link to a drug transaction, and therefore was the jewel, as it were, in that particular case.
The appeal court at page 14,
Yes.
near the bottom of the page, about 8 lines, 7 lines from the bottom, say, we consider that a corroborated case existed against the appellant without the necessity of taking into account the evidence of the statement given by Strong.
And I've just conceded that.
Yes.
I've not said it was decisive in the sense it was crucial. I'm not saying it was crucial for sufficiency. Therefore, when the Advocate Depute says it was not of such significance to be decisive, if he means it wasn't necessary for sufficiency, then I give him that. But what I say is it is wrong to jump from that to say it was just a circumstantial piece of evidence like any other. It was not. It was far more significant than any other piece of evidence. The second matter the Advocate Depute praised in aid, if I go through these quickly, is that the witness did not give evidence before the court. I'm not quite sure how that helps him, because that, I would have suggested to this court, makes matters worse. Because a witness who does not give evidence, having material with which to discredit him, is even more critical. Because your normal methods of undermining the witness are not present.
But, I mean, here, the witness was undermined.
Yes, I come to that. I do come to that. But I'm simply dealing with the issues as they are raised. And the second one is he wasn't giving evidence. Now,
well, it is true, though, isn't it? The second sentence is right. The point he's getting at, I think, is that it wasn't possible to put details to him, and therefore one of the uses which one might put outstanding charges to witness isn't available here.
yes,
For example, the accept he's trying to maintain he never was in trouble with the police.
yes, that's right. But The point I would make, the converse of that is that a witness by a Section 259 notice is for the Defence Counsel extremely difficult altogether, because it's almost undealable with, because there's no one near an oath, there is no cross-examination, there is no assessing the demeanour of the witness in the witness box. He may or may not have looked like a shifty character, to use a phrase, but we will never know that. So any ammunition you have to discredit him becomes all the more critical when you can't use your normal tools to discredit.
Just for the avoidance of doubt, the Section 259 notice allows the court
Yes,
to...
that's the method by which his evidence was led. I'm sorry. I'm sorry, my lords, that's the procedure under the Scottish legislation that allows evidence of a witness to be led without the witness being present.
And is the trial judge expected to give directions to the jury about the care that they should take?
I don't think so, do I? I think they point out, as he pointed out in this case, that he was not cross-examined, he was not on oath. They say those things. They don't give the equivalent of what I call an old Socius warning, but they don't, I think, tell the jury specifically they must treat the evidence with care, but they would tend to point out the limitations, that is. But he is always, evidence given like that is always extremely difficult.
He does say,
sorry?
He says, you're going to have to exercise great care. I mean, he says that in his charge, bottom of page 23, top of page 24.
Yes, I understood, my Lord and the Chair, to ask me was a sort of set in stone legal ruling that had to say that. I'm not aware of that, although I accept he said it very much in that case.
But I mean, had you known everything, are you in a position to say, I mean, you might have been able to object to his evidence being allowed in under Section 259, having regard to all this?
The difficulty, I think,
unable to...
I would like to say that I could, but I don't think I could have, because the law is pretty much settled that if he's dead, it is allowed in. It is a matter of assessment later on in the trace as to what can be made of it. It is very, very difficult to stop evidence being led under Section 259 if the witness is dead. Perhaps should be easier, but I have to say it's not at all easy. So I don't think that stopping the evidence would have been possible. My complaint is...
I mean, we've had, on this side of the border, we're giving judgment in a case, is it tomorrow, called Horncastle, which deals with a whole host of Strasbourg. Was anybody, absolutely, and there's a case called Rodger, and I mean, Strasbourg have put huge question marks over the use of dead witnesses and so forth. I mean...
I think that's in the context where it's sole or decisive evidence.
That's right.
Well, that is true. But, I mean, I think our own domestic legislation has built-in safeguards. I don't know.
But the point being made about sole and decisive evidence would apply, as I understand it, north of the border.
I see.
Where it is decisive, then we're into a different part. But in this situation, do I think, had I had this extra ammunition, I could have stopped it being led? No, I don't.
No.
I absolutely don't
that's
think
very
I could.
fair, thank you.
That would not have been something I would have tried or succeeded in.
The safeguard I had in mind was indeed a direction from the judge, which you accept was given.
Yeah.
Maybe nobody's actually written that into the statute.
No.
That's what one would expect the judge to do.
And I suspect, perhaps, generally speaking, they do. I'm not entirely sure of that, but I think probably they do. But my point remains that the fact he is not giving evidence is a point, as it were, in my favour, because I don't have the normal tools to deal with him. So anything I can have to discredit him becomes of all the more value, because I can't use his demeanour, I can't cross-examine him, I can't do any of those things. So having the discrediting tools is even more important with a witness led under 259 because of the fact that he's not presently. It is said, of course, and there's some force in this, and I think this is the point that Lord Rodger was making to me. It is accepted by all parties that Mr. Stronach was a liar and told many lies in his interview, and that is true. Clearly, the Crown case depended on him telling lies, because, for example, in his statement he said, Mr. Allison told me to take the car. But he did said he told me to take it for a different reason. The Crown wanted part of that and not part of it.
They said it was good to sell it or something.
To sell it. Yeah. And indeed in his speech to the jury is very much said. But I say that doesn't matter. The question is not whether he was a liar. The question is whether one could reliably believe anything this man said. And in the end of the day, the Crown are saying, yes, this person does not always tell the truth, the whole truth, and nothing but the truth. But it remains the position that this very significant part of the Crown case, and I go back to the fact it was significant, depended on that part of it, asking a jury to accept the man being truthful on that matter. And the question is not whether or not he was a liar in some ways. The question is whether or not he should have been believed on anything, whether he was a man that anyone could place any credence on or any reliability on. And the Crown, in my submission, can't get away from that by saying, well, we said he was not entirely truthful. And I was going to say in almost every case, in lots of cases, the Crown can find something to criticise in their own witness. That's not the issue. The issue is whether he can be believed at all.
Well, point 3, I don't know whether you finished point 2, but point 3 is making the point that it was accepted by all parties that he was a liar.
That's what I'm trying to answer, point 3 at this stage.
And there we are. What we have as the material for the outstanding charges, which have not been proved against him, of course, are 2 charges under the Misuse of Drugs Act, 1 charge of theft by housebreaking, and a number of road traffic.
Well, I'll come to that if I may, my lords, but that's right. But the fourth matter there is, because that comes into point 5, I think, the fourth matter the Crown raised is that the only evidence they relied on, that is the piece about the instruction to take the car to Ayrshire, was supported by independent evidence. Now, I don't accept that. I simply do not accept that. The independent evidence was that car being seen in the driveway of the appellant earlier the same day. Now, that is only, as it were, independent evidence to support what one knew anyway, that there was evidence of association with people. The key part of Mr. Stronach's evidence is the instruction he was given it. Allison gave him to drive it. The car in the driveway earlier doesn't help in that at all. It only adds to the general level of association. I'm sure the Crown played it in aid in the sense of it was part of the picture of association. But what they were really relying on in Stronach's evidence was, Stronach says, Allison, or the man who could be inferred to be Allison, told me to drive the car to Ayrshire.
I mean,
that's not supported. That key issue, which is a significant part of the advocate depute's significance, that's not supported by independent evidence at all.
I mean, obviously, I said, but I mean, the fact that the car was in the driveway that morning, and drugs are found in it later that day. I mean, it's part of the circumstantial picture.
Of course, I don't say it is not of value, but I don't say it is of much value. It supports that the fact that Mr. Allison associated with these people. It doesn't. The key part, what is really significant in Stronach's evidence by 259, is that we gave him the instruction to go there. That's what links us to drug transaction. The independent evidence doesn't help with that.
Does it speak to an association with the car?
Yes, of course. But if I'm associated with a person who has a car, I may well also be. It doesn't change the problem the Crown have of adding to giving instruction to go there.
Well, the significance of Stronach's evidence and the part of his evidence that the Crown wished to rely upon was to the association with the car, isn't that right?
Not quite. It's not an association. The crucial part of that so-called association, what takes up to the next notch, is that we were instructing him to make the journey with the car in a drug transaction. That's more than association. That's what links us directly into the drug transaction and takes it up a notch. The next point which is made is the point already mentioned, that the High Court have already considered the previous convictions and said that didn't matter. And that's where I was grateful to my Lord, because that's where I was going to say my answer to that was the answer I've already been given, that it is a cumulative thing. And you cannot look at it, the failure to disclose the outstanding cases, in the vacuum. It is going back to looking at the whole picture. Now, that is not revisiting, because I can't ask you to do that. I may not have liked it, but I can't ask you to revisit the High Court's view of the previous convictions. But this court is now looking at the totality of it, the cumulative effect. And as I've already hinted, who knows what the tipping point is? Who knows? All I know is that the defence did not have all the ammunition. Now, who knows how many bullets it would have been necessary to fire to get the desired result? All I know is that one of those bullets was not in the defence hands. And for all I know, that may well have been the tipping point. Now, I don't want to lower the bar to something which might have been. I'm trying to be realistic about it and say, if I have certain pieces of evidence or certain bullets to fire, if I may put it that way, if I am not given one of those, then that is material in a situation where I am back to, I can't cross-examine the witness. Not that I did the case, I may say, but the counsel could not cross-examine the witness.
But it's for you, is it, to show that it does tip the balance, rather than for the Crown to...
Well, one can never absolutely show it tips the balance. One cannot get the jury back in and ask them what they would have done, so I can't absolutely show it tips the balance. But what I can do is say, in terms of the test which has been outlined of materiality, in a witness that I can't cross-examine, and in a witness whose evidence by 259 is, I come back again and again, the most significant piece of evidence, it's not a circumstantial piece like any other, then not to have that is material in terms of undermining the Crown case.
I mean, I accept one sense, it's a disadvantage not to be able to cross-examine him. Of course, in another sense, he can't answer back either. I mean, you just have to take it. And, Mr. Watson was in a position to reveal all these lies and so on, and there was no comeback. A witness, the danger, of course, I don't need to tell you, Mr. Jackson, but the danger, of course, is the witnesses respond to.
But I take my Lord's point, but perhaps it's the arrogance of counsel. I would sooner have the chance at cross-examining them. I would sooner be in a position of taking them on if I could. So I don't consider it an advantage not to be able to cross-examine them.
Well, is point 6 really?
Point 6 is the same, I think. Point 6 is they would not have added anything. And I think that's really the same answer which I'm saying. Above that, it is the cumulative. One interesting thing in point 6 is said that some of these, I think the Crown mentioned the fact that the outstanding charges of the Misuse of Drugs Act would not have been used in any event because they would have linked us into a man with a drugs business. I don't accept that for this reason. It was never going to be in dispute in the real world of the case. He was associated with people like that. So, leading evidence that someone he associated with had a drugs conviction was not that harmful because that was past praying for. What was necessary was to say to the jury, you can't rely on this man. So I don't see how bringing out he would have had a previous conviction. A man, he would have been linked to a man who had outstanding charges for drugs matters, would have been of terrible importance because the Crown were proving that umpteen times. It was the real, so that wouldn't have mattered. What really mattered was having all the information available.
Could we just go through
to
the
deal with
sentences in 6 because it's
yes, of course.
quite an important paragraph.
Yes.
Leaving aside the first sentence, which you dispute, the second is right, isn't it? That gives us a brief description of the previous conviction.
Yes.
And then the third sentence is correct.
Yes.
I don't suppose the road traffic offences matter very much in this context, but theft and especially the drugs
Yes.
ones do. Now, there's then the possibility as to whether the theft one would add anything to the crimes of dishonesty that have already been established against him. What do you have to say about that? He's already been convicted 3 times for crimes of dishonesty, which passes out.
I accept that. I can only come back to the point I've made about the tipping point. That's the only way I can answer that there is a tipping point in a case. And who knows how a jury's mind will precisely work. They may also, there is the idea, which I don't know how this would have worked at the trial, that someone may have a motive to have outstanding charges. Juries, for all I know, may be more worried about people with outstanding charges. They may find it less, to my Lord's point earlier on about whether one would buy the used car from a man with a fraud outstanding charge. The lay person may have more worries about accepting people with outstanding charges than with convictions. All I say, it is cumulative. And when you can't cross-examine the witness and the evidence is as important as this evidence was, to be denied ammunition like that is material in terms of the test we have.
What about the last sentence? That one of the outstanding charges was known to the defence anyway, and evidence had been led in relation to it at the trial. Is that?
Yes, I think that was inevitable because I think that was to do with this transaction. I've discussed that this morning with the Advocate Deputy. We think the outstanding charge was the fact that he would have been in trial for this particular one. So that was inevitable. That was just part of the general picture, because he was the man who was caught with the £30,000 worth of drugs.
Absolutely.
So that was there. It wasn't anything. That wasn't something disclosed. That was something, in the true sense, it wasn't something disclosed. That was something which was known by definition. He must have had the outstanding charge because he would have been charged with that had he not done.
Left with one other, which was not the subject.
That's right. And at least other crime of dishonesty. This position is, and I think this
is... Lord Brown just asked me, do you know who actually owned the car? Do we know? Is that, I mean, if he was being sent to...
Not me.
Does anyone know?
No.
There's no evidence on it.
It's never been suggested it was my car.
No, so I just wondered. It's just...
And that's agreed. I don't know whose
it's not
car
your
it was.
car.
No, but all that would have mattered is it wasn't mine.
Yes.
I think that would have been different. I think had it been Mr. Allison's own car, then that would have added another complication to my position, but it was not.
It was.
Yeah, but he didn't really blame us. And who knows how the jury might have dealt with it, because obviously had he lived, he would have been a co-accused. He would have had a motive to tailor things to suit himself.
Would he have been tried first?
I don't know. I mean, I just genuinely have no way of knowing that. But at the stage when he's being apprehended by the police, he knows he's going to be accused of this. He does have a motive, is all I'm saying, to tailor matters. And the position remains, of course, and I think this is accepted, before the trial, the defence asked for this material. The defence asked for this. This was specifically requested. I think that's common ground between us. The defence sought the material. Both previous convictions and outstanding charges. But in terms of the culture of the day, they did not get them. I think the letter was sent for completeness on the 24th of August 2004.
Respond to the next day. Respond to the next day by saying one outstanding.
And there was a response the next day from the Crown Office. Not giving that information is all I can say. The point I'm making is only that it was asked for. They wanted it. It was ammunition that the counsel who were involved felt have value in their hands. They didn't get it. I have argued, we've agreed they should have got it, we've agreed the test, I'm not disagreeing with that. I have argued, I have sought to show why it was material. If I am right in that, then I think I win, if I may put it that way. But if I'm wrong in that, then of course I can't. The only other issue is the only other matter of dispute is what should be done.
just before you leave them.
Yes, of course.
Item 7, I think, is simply a passage at the end of paragraph 10 of the appeal court's judgment, where they say that you had acknowledged you couldn't know precisely what use you would have made of material, but it would have been deployed, really, I think the point you're making is supporting all the other materials.
Absolutely. But when they say I didn't identify any specific use, I take the word for that. I have no memory of what I said in that occasion.
So disposal is...
Well, disposal, because there is an interesting suggestion, if I may put it that way, from the Advocate Depute, that if I got to a certain stage of success, then it should simply go back to the Scottish Appeal Court to reconsider the question of materiality. I think that's the suggestion. And I would not accept that. I think one would find that suggestion for reference in the submission of the respondent at paragraph 18. As far as I'm aware, that's not been the approach which has been followed in this court.
Well,
I may be wrong in that.
reference is made to the Supreme Court rules, which simply say we have all the powers
Indeed.
below.
I'm not saying it would be incompetent to do that. I'm simply saying it's not an approach I have seen followed. Where this court has heard that there has not been a disclosure, they have looked at the test as materiality, they're satisfied it is material in the particular case, then they have dealt with the matter. They have not... Because if that's wrong, then all this court will ever do is decide should this have been disclosed and send it back. That's all this court would ever do if that approach is right. In other words, everything we're in agreement with would detain this court for no time at all. They would simply send the matters I've actually been spending time on back to another court to deal with. Now, that has not been the approach which I can find this court has taken.
Well, it may depend on the case, Mr. Jackson.
Right.
I can see there could be cases where the facts are so complex.
Yes, that's
The
right.
assessment is so...
That's right. I concede
It's not
that.
really part of the Supreme Court, given its relatively limited jurisdiction under the devolution legislation, to that exercise.
Oh.
There may be cases where it's very clear it wouldn't have made a difference. And that may be the crimes case, in which case we can simply resolve it
Well,
by dismissing the appeal.
No, I totally follow that, and I can see there are complex cases where it would go back. All I would say is this is not one such. And when I look at the cases which have been here, for example, Sinclair, for example, where this court has looked at it and then decided the materiality test is satisfied, this case would be no more difficult to deal with on that basis than a case such as that. In other words,
Which is the other case?
the case of Sinclair, just
Sinclair,
I just
sorry,
give that as an
Sinclair. No,
example.
I didn't hear what you said.
As one example of a case where this court has dealt with it to the end stage. This case is no more difficult to do that with than, say, that case. I accept there may be cases, my Lord and the Chair says, where the complications of facts are such that you just don't want to get involved in it. But I don't say that this is a case like this. And I'm fortified in that by the Advocate General agreeing with me as far as I can see. Because at paragraph 28 of his submission to this court, he specifically agrees with what I'm saying on that and states that the proper procedure would be, if we are all agreed in the law and if the facts of this case, as I've tried to demonstrate, mean that this was material, then this court should quash the conviction. And as we're not dealing in the jurisdiction matter, I think that may be...
I'm sorry,
me.
what are you suggesting? That the... What's his name, Mr. The intervener...
The Advocate General.
The Advocate General. Paragraph 28, he's not agreeing, is he? I mean, is he saying that this is necessarily a decision for us to take? I mean, if you get to that point, rather than sending it back?
I thought he was.
Well, he may be, but...
Maybe I'm wrong.
I thought 28 says that if we find that Article 6 is breached...
Yes, but it's only breached. That's coming to the same thing, because it's only breached if I'm right.
Well, his case, I think, is the same as it is in McInnes. I think it's pretty well word for word the same. And the issue in McInnes is really whether, in looking at at Article 6, one can take account of the functions of the appeal court in having the ability to remedy a failure to disclose by looking at all the material.
Indeed.
We'll come on to that in McInnes
Indeed.
to discuss in more detail.
But I don't understand paragraph 28 to be disagreeing with what I'm saying, because he is saying there that where it's been breached, then it would quash the conviction. Now, breach arises from more than just non-disclosure. For there to be a breach, I have to get over the materiality hurdle as well. I accept that.
Well, there is, no, I mean, with respect, Mr. Jackson, there is a breach.
Yes.
I mean, there's a duty
Yes, okay.
of disclosure.
Yes, there is.
And there's a breach of that duty of disclosure. So that to that extent, Article 6.1, if you like,
Indeed.
has been
I understand.
violated. The question, nonetheless, is whether or not, looking at the whole thing all over, there has been the trial has been unfair, or whether or not it's caused a miscarriage of justice, however one likes to put it.
Indeed, and I take those to be the same. An unfair trial and a miscarriage of justice, I don't draw any distinction. But my submission is quite simple. If this court holds as a breach, which it will do, I assume now, the court should look at the reasons I've given why the materiality test has been passed and should quash the conviction rather than send it back.
Well, I think the Lord Justice General in McInnes accepted the Sinclair approach if it's a clear case that not unreasonable for the Supreme Court to simply set the conviction aside.
At my submission, this is not a case of such complexity that would fall out of that definition and go back. And therefore, my submission is, in this case, it falls within the category that this case, this court should take to its final conclusion. I don't think I have anything else to help with.
Thank you. Ms. Mitchell.
I have nothing to add.
Mr. Deputy.
Sorry,
That's right.
My Lords, in my submission it is necessary to have an understandable system which ensures a fair trial to those accused of crime and which is capable of robustly dealing with a complaint that there has been an unfair trial. My Lords, in my submission, the right to disclosure of all relevant material has a broad scope and includes material which may only have a marginal bearing on the ultimate issues at the trial. Accordingly, a failure by the Crown to disclose disclosable material may meet the threshold, as in Murter, tab 10 in the Allison volume of authorities, but could not possibly affect the reliability of the result reached in the trial or the overall fairness of the trial process. The defence may not be impaired as a result of the obligation to disclose not being complied with. It is obvious, I submit, that a finding that an accused's right to disclosure has been violated does not end the analysis. A failure by the Crown to disclose material may be incompatible with Article 6.1, but it by no means necessarily follows, in my submission, that the accused has not had a fair trial in terms of Article 6, or that there has been some other miscarriage of justice. And I take up the point made by my Lord Rodger in MacDonald, found at tab 10, paragraph 77.
Is that because the appeal court, or the Supreme Court in this case, if necessary, can examine the material which wasn't disclosed and form a view as to whether it would have impaired the defence or would have been violated?
Yes, precisely, my Lord.
What is the test that we apply then in looking at the material?
I invite your Lordships to take the test as being a real risk of prejudice, which was the test was applied in McInnes, and your Lordships will hear further argument in that. I submit that...
Sorry, where does the real risk of prejudice come from?
It's referred, that was the reason given in McInnes.
By High Court in the McInnes case.
Yes.
I see, yes.
I submit that regard must be paid to the dynamics of the trial and to the live issues. That requires a two-step process, A, the non-disclosure, and B, the impact of non-disclosure on the decision to convict. This requires an assessment of the realities of the trial, including the weight of the other evidence, and that is the analysis of Lord Bingham of Cornhill in the Queen against Farrell, as referred to in Murter, tab 6, the bound volume, paragraph 75.
Sorry, can we, murder is the last word on all this, is it?
No, my lord, in my submission, murder deals with the obligation to disclose. That's the first
corrected, the latest word. The last word, no doubt, is years down the line. Where in
It's tab 6 of the joint volume.
Which bit?
And it's paragraph 75, which is on page 25.
Yeah.
And the quotation there by Lord Collins, Farrell, in which Lord Bingham sets out there. Thus we have a clear and simple case in which the convictions of the prosecution witness were not disclosed when they should have been as a result of inadvertence or oversight. What is the effect of such non-disclosure if a defendant is convicted and evidence of convictions on the part of the prosecution witness then comes to light? There's no simple and straightforward answer to that question. The answer will depend on the weight of evidence in the case apart from the evidence of the witness whose convictions have not been disclosed. The greater the weight of the other evidence, the less significance, other things being equal, the non-disclosure is likely to have had. The answer will also depend on the extent to which the credibility and honesty of the prosecution witness whose convictions have not been disclosed is at the heart of the case. If, as here, the prosecution witness whose convictions have not been disclosed is the only witness against a defendant, and his credibility and honesty are squarely in issue, and the jury are led to believe that the witness is of good character when such is not the case, then there is a strong ground for contending that the conviction is unsafe. And one can see that as an obvious example where non-disclosure would have a quite significant impact upon the actual live issues at the trial.
When you look at that sentence, I think halfway down the quotation, the weight of the other evidence, in this case, is it possible then to take account of the previous convictions, which have been now taken into account by the appeal court? We're
yes.
Concentrating on the outstanding charges.
Yes, yes.
So one assumes now that the non-disclosed previous convictions have been taken into account.
Yes. Well, indeed so. In my submission, they in themselves don't add very much anyway. But yes, as part of the overall picture of the status, as it were, of the deceased witness. In other words, my lords, in my submission, it's not the application of a simple equation, non-disclosure equals unfair trial. And a good example of this can be seen in an English case, the case of the Queen against Craven, which is tab 16 of the joint bundle. And I don't propose to go through the case in detail, but in that case, a young woman was murdered, the murder weapon being a pint glass. A third-party fingerprint was found on the glass, and this was not disclosed. On the face of it, that might give rise to real prejudice, but as explained in the case, the court considered that the undisclosed evidence, in the light of the material available, and as to what extent the non-disclosure affected the verdict of the jury. In so doing, the court was not restricted to a consideration of that evidence in the context of the information which was available to the jury at trial, but it was entitled to look at the evidence now available. This properly secured the rights of the defence for the purposes of Article 6.
Where do we see the principle stated?
It's page 196 of the judgment itself. At the top of the page for the opinion of the court. In determining in any given case whether or not there has been such unfairness as would render a conviction unsafe, it is necessary firstly to have regard to the particular vice which it is said to constitute unfairness, and secondly, the extent to which the appeal court is in a position to correct that vice. At one end of the scale will come those cases, such as those in which the prosecution amounts to an abusive process, where clearly vice cannot be corrected on appeal, is of itself sufficient to justify the conclusion that the proceedings are unfair, and as Lord Justice Rose held in the case of Mullen, referred to in the judgment of Lord Chief Justice, unsafe. Further, there are cases where the independence of the trial court is called into question, and go on to make reference to Finlay against the United Kingdom, that held that a person charged with a serious offence was entitled to first instance tribunal which fully met the requirements of Article 6.1. Again, there could be no question of that being capable of being rectified by the process of appeal. And reference is further made to Edwards, to which I'll return to. However, in Edwards, the European Court of Human Rights had to consider the question of whether or not the fact that evidence had been withheld from the defence at trial rendered the proceedings unfair. The same issue as is raised in this case, the Court of Appeal in that case considered that the evidence that had been withheld in the light of all the material available, and concluded that the evidence that had been withheld would have made no difference to the jury's verdict. The European Court of Human Rights held that the proceedings were not unfair. Although there had been a defect in the trial at first instance, that had been cured by fair and proper consideration of the evidence in the Court of Appeal.
I think the last sentence of the next paragraph is helpful too.
Yes.
It says the critical question is whether in doing so we're restricted to a consideration of that evidence in the context of the information available to the jury at the trial, or whether we're entitled to look at all the evidence that's now available to us.
Yes, and
that goes back to the point that we do now have previous conviction.
Yes. Yes, and of course, and must take account of that. And that's in line with my Lord Hope's approach in Murta, paragraph 10, again found at tab 6.
And do you accept in the middle of 58 the test there, entitled to consider whether the material which was withheld could have affected the jury's verdict in the light of all the facts now known to this court? If it could have done, the conviction would be unsafe. Is that the right approach?
If it's interpreted as meaning in a real sense, not in some hypothetical, fanciful possibility, but in a material sense, such as to render real questions about the jury's verdict. I mean, all information could in some way...
Well, you can see the antithesis in the next sentence.
Yes.
If it has not undermined in any way the verdict.
Yes, and it would. I submit it would have to meet that threshold.
Does that chime with the citation from Lord Collins in Murtaugh of that American case where the test was a reasonable probability sufficient to undermine confidence in the outcome of the trial?
Yes, if that's what it's taken to mean, and I submit it needs to be in that form, then yes, I submit that that's what is required, and that is what needs to be demonstrated to your lordships.
I think, strictly speaking, under the statute, the test for Scotland is whether there was a miscarriage of justice. Isn't that right? And we've got to be rather careful that we're in the Scots appeal, we use the correct hand for the miscarriage of justice, which may be expressing the same.
Yes,
point.
yes.
There may be some debate as to whether they're precisely the same, but that is the test ultimately.
Yes, and that's what I submit it comes to, that there has to be something that can be pointed to of substance which amounts to a miscarriage of justice, not that there some remote way another tactic could have been employed. In this case, as is obvious from the case on behalf of the respondents, it's accepted that there was a potential infringement of the appellant's right under Article 6. But I submit that it is necessary for the appellant to demonstrate that there was a real risk of prejudice, such that the overall fairness of the trial has been adversely affected. And that must be based, I submit, on the basis that the defence has been deprived of opportunities to pursue additional lines of inquiry or garner additional evidence flowing from the undisclosed material.
I mean, if all this stuff had been disclosed, presumably, even though the witness was dead, they would have been able to adduce before the court this material, and they would have been able to say to the jury, well, now look here, this is a deep-dyed crook, not only with a host of convictions already recorded against him, but with various outstanding matters. Who knows what pressure he might have been under to assist the police in this and all the rest of it. I mean, they could have done it. The question is that right? I mean,
They could
that
have
would have been
done
open to them.
Yeah,
But
yes.
what you say is, well, for the best one in the world, it couldn't have availed them one iota.
That is my submission, but I also question whether strategically the defence would have been likely to align themselves with someone with a close association with many outstanding cases in drug trafficking. But that would have been available to them. But this is not a witness who was presented as whiter than white without any difficulty at all. This was a witness.
Can you just remind us how he was presented? I mean, is this bit we were looking at?
It's the best place to go with the
Tab 5.
Trial judge's report.
Tab 5, isn't it?
Well, the tab 8, I think.
Oh, sorry, I see. No, I see. So is this the bit we were looking at before? The first time?
Are we going to the trial judge's report? Is that?
Yes, just
Which bit of that do we want?
the supplementary report, which is date stamped the 8th of March 2007, which is the first one.
I thought it was the third one which gave the...
Or the third one.
Third
does.
one is the one which goes into the evidence, I think, in Wilson Street. Am I wrong?
No,
I mean, that's where we find the evidence.
Yes, it is, the third one.
I know, but how was he... how was he put to the jury, this
That's a
dead
page-
chap?
Page 9, I think, tells us how it was done.
That's it. If one goes, it's at page 22 of his
22,
of the charge.
so that's 22 of 5, is it?
Yeah,
Yeah.
22 on again. 21, 22,
Yes.
23.
Stronger is strong. Take it.
All right. Stroner.
You heard his voice. It was actually... So it's a tape recording which is played to the jury.
Yes, it should be Stronach.
And then this bit at the top of 24, you'll have to approach where he says caution for a number of reasons.
Yes,
Cross.
on page 23, explains the particular status that he has. At the bottom of page 23, line 23, you will have to decide whether what should be John Stronach said is credible and reliable, and in doing so, you will have to exercise great care. You will have to approach what he said with caution, and this is for a number of reasons. First of all, the evidence is not given under oath, and he explains that. And he also explains there's not had the opportunity to see him being cross-examined at lines 16 and 17. It's not tested. At line 19, his lordship said, it seems pretty clear, accepted really at all hands by both the Crown and by the defence, that in the course of what he told the police, he told many lies, both about what happened on the 24th of November and about other matters. Much of what he said was contradicted by the contents of surveillance logs, it should be, and the other evidence such as the searches of his house referred to in the drug inquiry or whatever. There is, however, a passage in which the Crown do seek to rely, and that is what he said about a man called Stevie from Abram Hill, whom he described and said that he had asked him to take the car down to Kilmarnock, and the Crown suggests first that you could infer that that was a reference to the first accused, and that if you took the part that if you accepted Mr. Stronach's account, the man Stevie had made an arrangement and told him to take the car down, rejected his qualifications, that it was for the purpose of selling the car, and took that along with other evidence in the case, then it pointed to the first accused being concerned in the supply of drugs. The Crown suggests to you you could find comfort for accepting that particular part of his evidence in the interview from the evidence of Detective Sergeant Duncan Smith to the effect that he saw the Peugeot car in the driveway of the house about lunchtime on the day, and also I think the Advocate Depute referred to in evidence that on the 27th of November the first accused took the passport of John Stronach to Airdrie Sheriff Court for all the purpose of Mr. Stronach being released on bail on the charge that related to the journey to Ayrshire. Now that's a compelling piece of evidence as well in my submission, and indeed that there was reference to the other journey linking the appellant, and it's described as being a spectacular coincidence by the Advocate Depute if these things were not connected. And that, of course, was precisely a matter for the jury to assess. But he was not presented by the Crown, it's ultimately a matter for the jury, he was not presented as an absolutely honest and truthful man. And indeed, while it's not evidence, of course, what the Advocate Depute said in his speech, the acceptance of him being a liar would, in my submission, carry significant weight in the deliberation of the jury, and the invitation to only rely on those parts of his evidence which were supported by other evidence was another safeguard. So it was pretty clear in my submission that this is a witness who could not be trusted, but on key parts the Crown invited the jury to accept evidence which was capable of being looked at elsewhere. In my submission, that there was plainly sufficient evidence without the 259 statement and the direct link. Because
nobody disputes that.
No, but it was there. And in my submission, had the witness been presented as entirely credible, with nothing lurking around this at all, then the position might have been different. But that's not the situation. In my submission, this is a case where even applying the lowest possible threshold test to determine whether there has been an unfair trial, that test would not be met. There is no prejudice, I submit, in this case. There's not a case where there was not even no risk of prejudice. There was no prejudice. What my learned friend Mr. Jackson says is that he wants all the bullets, but that, my respectful submission, appears to mean no more than to fire the last bullet into the dead body. There's no purpose to be achieved with that. That jury could be in no doubt of the status of Stronach, and in these circumstances, this would have added nothing to the significant body of material and successful attack upon the credibility of the witness as recognised by the trial judge, and therefore applying the two-stage test in my submission, the appellant should fail in this, that this would not have affected the outcome of the trial at all.
Does that bring us to disposal then?
Yes. On disposal, as set out in the case, the Crown invites your Lordships to simply, firstly, answer question 1 in the negative, but if your Lordships take a different view that the appellant...
Sorry, what's question 1?
That's...
Whether the failure was incompatible with the right to a fair trial.
Yes.
And that is on the basis that the violation can be cured by an analysis of all the material
Yes.
available
Yes.
by the appeal court.
Yes, that's the position. And if your Lordships take the view that the appeal court have not approached this in a proper way, then the Crown's invitation is to send the case back for it to be considered.
But you accept that they didn't approach it in the proper way.
I'm sorry, my Lord?
You accept they didn't approach it in the proper way, because they ruled out.
Yes. Well,
You're not supporting the Court of Appeal on that.
oh no, I'm not supporting... Oh, no, but they held there was no miscarriage of justice. Sorry, that's what I meant to say, that they ultimately concluded there was no miscarriage of justice. But I don't see, and I make it clear, I don't seek to support the observation that there was insuperable difficulty in deploying outstanding cases. I don't seek to support that at all, and it's pretty obvious perhaps that nothing further need be said about that, but I don't support that, unless it's taken to mean its application to the present case only, although a pretty ordinary reading suggests a wider application. But if that's what is meant, I don't support that.
It's difficult to believe that's what the court really meant.
Yes. Yes. But if you're...
So who has to take the decision whether this failure to disclose these in addition made a ha'porth or a pennyworth of difference?
Well, I invite lordships to take that view and just to conclude that it made no difference, and that's
for us, is it? We wouldn't want to send that back.
So we can dismiss the appeal, but we can't allow it outright. Is that right?
I'm not specially pressing either. I made it clear that equally, if the court wishes to resolve...
Why does the Crown take this idea of... Where has it got this idea of sending it back from? Why is that?
Well, it's really more in a principle and perhaps designed to stop your lordships being troubled with many cases which will have a lot of events turning on the evidence. This is quite straightforward in terms of the evidence, but many cases will not be. And
one is aware that there's some feeling in Edinburgh that we shouldn't be too adventurous in exercising the functions which they believe they have. But in this way, it's clear, and I think the Lord Justice General accepted this in McInnes. There really is no reason why we shouldn't simply do the sensible thing and dispose of the case here, is there?
no, I don't argue against that.
I mean, now that it's known that you ought to disclose this, that and the other, I mean, why do we have to get it here? Why can't it all go back for another shot in Edinburgh? I mean, isn't there some process of referring back appeals that have been dismissed on a wrong basis or whatever it may be?
Yes, and the first suggestion was that could be done if your lordships are not satisfied that a test...
But why has it got to come near us? I mean, after Murtaugh, presumably everybody recognised, as you're recognising, that here's a case where not only should the previous convictions, but also the outstanding charges should have been disclosed. Okay?
Yes.
Well, why can't it then go back to the appeal court in Edinburgh for them to... Why has it got to come here?
Because they can't.
Well, firstly, I didn't bring it here.
No, but I mean, is there no mechanics? I mean, isn't there some...
No, I mean, they had decided, despite what had been said in Holland or whatever it was, that they didn't take the view that outstanding charges were, and that was the view they took. Once they'd taken it, there's no mechanism, as far as I know, short of going to the commission or whatever it is, for dealing with that matter. So they took the obvious route and they came here.
And we gave permission, in fact, in this case, because, first of all, we had to be satisfied
Yes.
that it was a devolution issue, which you accept. And this court gave permission for the point to be argued, so it is properly before us.
Yes.
And the question really is, having, as it were, received the case and examined it, whether we have to send it back or whether we can exercise the powers we have under our own rules to dispose of the case. And in the end of the day, I rather think you accept that provided it's a fairly straightforward issue, we could simply do that.
Yes.
And trouble the court in Edinburgh with the case again.
Yes.
I think they've got plenty to keep them busy, as far as I can understand, so I don't think they're needing any extra work.
And I don't say anything about the jurisdiction point. But my lords, those are my submissions, unless I can assist your lordships with anything further.
I have nothing to add on this.
General.
With a certain diffidence, there is one small, limited additional point that may arise, and I stress may arise, and it's simply on the distinction, whether there is a distinction, between the concepts of unfair trial and miscarriage of justice. Now, the reason I raise that, although the appeal court appeared to take, in this case, the leading from unfair miscarriage of justice. The reason I raise that is that Osborne, in the case of Fraser, seemed to envisage that there were two separate which in some way could not meet. Now, I fully appreciate that Fraser is before this court in that there's an application for special leave, which I understand awaits the outcome of this case. If I just cover the point briefly then, Lords. In Fraser, Lord Osborne identifies that there is a difference between unfair trial leading to what he describes as a nullity and distinguishes that from miscarriage of justice pursuant to two entirely separate routes. One lies with the Supreme Court, whereas miscarriage of justice lies and stops with the appeal court in Scotland. This seems curious, although he identifies that they need not always be equal in outcome, he identifies this difference between nullity and miscarriage as somehow being really a difference. However, in Allison, he seems to possibly have recanted because he sees the unfair trial leading into miscarriage of justice. And certainly, in broad language, one can easily anticipate why he would come to that outcome. The only reason I raise this, Lords, and I will not tell Lords much further on that, is simply that he identifies in Fraser this apparent difference.
Is this a point you're going to come back to in McInnes?
Lord, no.
You're not?
No. There may be a question in relation to real risk of prejudice as a formula, which I might deal with in McInnes. But this point seems to arise only in this decision, but only because of Lord Osborne's observations in Fraser. This is set out in my statement of case, and perhaps covers the point sufficiently. Beyond that, my Lords, in relation to disposal, which my statement of case is made by the appellant, effectively what I am saying is that where there is an unfair trial, and my Lords find that to be the case, then it does seem to be, with respect, the sensible thing simply to quash at this stage, and that this court has these powers. And if there were any doubt about that, I'd refer to the Constitutional Reform Act 2005, which sets out how to do justice with this form. Again, I will not that point. Beyond that, my Lords, unless there's anything further which I might assist, Lords, that would complete.
Thank you very much indeed. Mr. Jackson.
Well, I certainly have said most of what I want to say, but just one or two things perhaps. It has to be remembered in my submission why, in the first place, outstanding cases are material which should be disclosed at all. And it is because there is a recognition that they are the sort of things, the category of things, which a defence counsel would wish to have. They are not unimportant matters, which of course ties in with the fact that in this case the defence asked for them. So they are matters of some importance, or else they would not be material which required to be disclosed. That, in my submission, is the very important starting point. And the second thing I would say, and only this, it is, I hesitate to use the word disingenuous, and I mean no disrespect by it, but for the Advocate Depute to say that would have been firing into a dead body is not consistent with the position adopted by the Advocate Depute at the trial, because he was not presented to the jury as a dead body. He was presented as someone who could be used on a matter of great significance.
Well, of course, he hadn't been hammered with the previous convictions at that stage.
Indeed, but I venture that the Advocate Depute would not have been abandoning this piece of evidence no matter what had been put to him. Yes. I don't think no matter how many bullets had been fired into him, he would not have become a corpse as far as the Advocate Depute was concerned. And that is why he goes on to say in the passage I read, I will not read again, he describes this as being a significant piece of evidence. Now, you cannot have it both ways. If the previous convictions would have turned him into a dead body, then the previous convictions, plus the outstanding charges, certainly turn him into a dead body. And if he is that, then the fact that he became a material piece of evidence, almost by definition, means something has gone wrong. So it must be disingenuous for the Advocate Deputy to describe him at any stage as a dead body, because if this disclosed material had made him that, then the appeal in my submission would require to succeed, because clearly it would have mattered. Because the fact of the matter, he was not treated by the Advocate Depute as a corpse. He was treated, and would always have been treated, as being of some significance.
He was treated as a highly flawed witness, but on this one area, he was to be accepted. That was what they said.
Yeah.
Indeed, but it is that one area that was an area of extreme significance, and that is my point, that this was one area of great significance. And the question is whether he could be relied upon at all, and that, of course, is the cumulative effect and tipping point. I don't think I can add anything else. I just listened to the intervention and the difference between the two tests, and I do notice that the Lord Justice General in McInnes, because I read McInnes just from before I came, actually seems to suggest they were the same. He actually uses the phrase at one point in McInnes, a miscarriage of justice, bracket, or I venture to suggest an unfair trial. So there seems to be an acceptance, rightly in my submission, to really come to the same thing. But that's me just, as it were, intervening on the intervener. It doesn't really add much to my particular case, and I don't think I can, subject to this. So I don't think I can add any more. I think the submission has been made. Thank you.
Thank you very much. Well, the court is extremely grateful to counsel for their assistance in this case. We will take time to consider our judgment. We're going to move on to the case of McInnes, and what I suggest we do is that we adjourn until 12:15, and we'll come back and hear the case of McInnes at that time.
Claire is making the point that we clearly didn't think about that. You're talking about firing into a dead body. In fact, he was a dead body. He was a All rise.
Yes, Mr. Carroll.
Well, in light of the debate, much of what I would have touched upon would have been addressed.
Well, please don't feel inhibited.
The reason this matter is before this court is that the High Court granted leave to appeal, having recognised that in the McInnes case, it feels that it departed from or moved away from the test that is applied in Holland, in the Hodge-Clark test. Now, I do appreciate, Lords, that the Crown's position is the test that was applied was in fact the same test as was applied in Holland. But in my submission before this court, Lords, there are two reasons why I say that that is not correct. The first is that the court, by the words used in McInnes, at paragraph 20 of its judgment, indicated that it was wanting to depart from the Hodge-Clark test in McInnes, pointing to a text.
But I think it would help if we just looked at the relevant passages so we can get our bearings.
It's at paragraph 20 of the decision in McInnes, Lords. It's item 4 within the core volume. The Lords will find it there.
Appendix Part 1, I think it is, isn't it? And it's the Lord Justice General's opinion, paragraph 20.
Yes.
Is this at page 25 of the bundle?
Yes.
It is, yes.
Yeah.
About halfway through that paragraph, Lords, the court states, it is not, however, in our view, entitled to in effect, to avoid that task, and the court is looking at the task of assessment.
Sorry, where are you reading from paragraph 20?
About halfway down paragraph 20, my Lord. The first words in that line of miscarriage of justice, then it goes on to state in a new sentence, it is not
Yeah.
And the court refers to the test. This is a test which depends simply on whether the denial of access quote, might not possibly have affected, close quote, the outcome. Such a test was adopted in Hogg v. Clark, per Lord Justice General Pride at page 10, where there was a wrongful exclusion by the court of admissible evidence based upon prior authority, also concerned with the wrongful exclusion of evidence in summary proceedings. The court goes on to say that Lord Soane in Hogg v. Clark at pages 11 to 12 took a less absolute approach, concerning himself with whether the exclusion of the evidence had prejudiced or might have prejudiced the defence. Lord Justice General Clyde's test was adopted in the context of non-disclosure of outstanding charges by Lord Rodger in Holland at paragraph 82, though it is not apparent that what was the appropriate test was a matter of argument before the Judicial Committee, and Lord Rodger's test is not repeated in Sinclair, which was concerned with undisclosed statements. In the latter case, Lord Rodger was in a position to conclude that the appellant, Solicitor Advocate, quote, would have been in a position to cross-examine Miss Ritchie effectively, and the appellant's trial as a whole would have been fair, paragraph 50. Lord Rodger's test has been used or abused in argument in this jurisdiction to suggest that the threshold for reversing the verdict of a jury in a non-disclosure and analogous cases is low. That this may be a misreading of Lord Rodger's words in the context of determining whether there has been a miscarriage of justice or, we venture to think, an unfair trial. A robust test is required. The test of a real risk of prejudice to the defence was rightly, in our view, adopted in Kelly versus Her Majesty's Advocate at paragraph 33. Now, my Lords, I'll return to that part in a moment, but the second reason I say that the court adopted the wrong test, or it can be shown that it adopted the wrong test, is the way in which it treated the previously withheld evidence, in this case, in the context of the rest of the evidence. When the appeal court came to look at what was not disclosed at the trial, they appear to have taken a very strict approach, suggesting that the barrier had been raised. Now, Lords, it was never argued, referring to the first part of this point, it was never argued in the appeal court that there was a low threshold. What was argued was that, and quite rightly in my submission, and it's accepted by the Crown, is a threshold, the test is materiality. It could never be suggested that a piece of immaterial information, such as who took photographs, could affect the outcome of anything. It may be if the person who took the photographs heard a comment by a complainer, for example, but generally speaking, it can't. It's materiality. Now, it was also accepted at the trial that the court must make some assessment of the withheld evidence in the context of the evidence that was led at trial.
So just to be a little more specific, we're dealing, I think, with the witness Brian Pierce.
Yes.
Is that right?
We are.
And he attended an identification parade, and he made certain remarks when he was leaving the parade which were recorded but not disclosed.
That's correct.
And that's material. So the question is what one makes of that, there having been a failure to disclose.
Yes. The failure to disclose in relation to Mr. Pierce is possibly better understood, I would submit, my lords, if we understood the rest of the evidence in the case, and particularly what Mr. Pierce had to say from the moment the police spoke to him. And that can be encapsulated fairly briefly, if my lords would trust my recollection of the narrative, without having to go specifically to each statement. There was an incident, not an untypical incident, of course, a fast-moving, violent event where lots of people were doing various things to different people at different times. And Mr. Pierce was one of the stewards on duty at the particular hotel where this incident occurred. Now, when he first spoke to the police about 3 o'clock in the morning, shortly after the event, he initially described 2 people as having attacked Mr. Sweeney, the complainer. He did not describe in his first statement to the police anyone with a black jacket, a black leather jacket, and by that reference I am talking about the appellant here, McInnes. In a second statement given that same day, about 8:40 p.m. on the 16th of December 2000, Mr. Pierce then introduced in his information to the police the description of the roundhouse kicker, who was ultimately, in his view, Mr. McInnes. And it was in that second statement that the first indication of some error or some uncertainty in his position was shown, because his first statement described somebody with a tan fleece jacket and a scar on his face having actually been involved in attacking the complainer. In his second statement, he made it plain that the tan fleece with the scar was not involved in attacking the complainer. So he was starting to change his position slightly, at least as far as the police record was concerned. Now, on that occasion, on the 16th of December, about 40 hours, he was also shown a photo board, and the photo board, and there's an error in the case that was presented, I'll clarify that for my lords, but the photo board showed what the police would have regarded at that time as possible suspects. Undoubtedly, that's the police practice. And he was not able to identify anyone from that photo board. Now, none of that information at that stage, or at the stage of the trial, was known to the defence. But when it came to August of 2001, when Mr. Pierce attended an identification parade in which Mr. McInnes was placed, he thought he recognised Mr. McInnes. So his position, we can see, changed from the very start.
Where do we see this most conveniently summarised, these various stages? Because the statement of facts and issues doesn't seem terribly helpful on this, does it?
Yes. The statement of case for the appellant, my lord, does go into some of the information in relation to Mr.
Wouldn't it have been
Pearce.
helpful for a statement of facts and issues to chart a course of description by this witness, if that's what you're going above all to rely on?
It may have been, my lord, but listening to the debate this morning, I wasn't aware that the court would be wishing to go into it in that much detail, but my impression from listening to the debate this morning was that the court would probably be interested in going into some detail.
I mean, where in your... you ask us to look at your statement of case, do you? Where do we see it all set out chronologically?
It's in paragraph 5.2 of the statement of case, which is in the core volume at page 66, my lord.
But why are there two statements of facts and issues? Were you unable to agree a statement of facts and issues, which is what the rules say should be done?
The Crown's position, my lord, in the facts and issues was somewhat different from the defence. Originally, when the application for leave to appeal was discussed and granted, it was in relation to the test to be applied and the approach to be followed once that test had been identified. The Crown's position is that they look at the proceedings, I suppose in the round, but look at the proceedings taken as a whole. There's a slightly different position adopted by the Crown in this.
Well, it's not very easy for us. There's also a mistake in dates somewhere, because one version refers to the trial as ending on the 15th of December 2002, which doesn't seem to be right. And the Crown's version says the trial ended on the 13th of December 2001. And then we've got, as you point out, different issues. But are you agreed that the issue that we should really be addressing is the one in the Crown version, which directs attention to the question whether the procedure before the appeal court was sufficient to remedy the unfairness?
Not entirely, my lord, I have to say, not entirely. Because the procedure before the appeal court would have remedied unfairness in my submission had the appeal court adopted and applied the correct test. That would have resolved it, or could have resolved it. And had they applied the correct test, my submission is that the conviction would not have been allowed to stand.
I mean, I'm not sure that your 5.4 says quite all that you told us a short time ago.
No.
Was said at that 8:40 second statement meeting on the 16th of December.
No, my lord will see that in item 1.
So, but am I right in thinking that your 5.4 doesn't tell us all we need to know about the 2040 second plea statement, or is that wrong?
My lord is correct. It's in the body of the whole of the core
That's
volume.
why I wondered why we haven't got some convenient statement of the succession of statements. Anyway, so where do we find what he said then?
Apologise, my lord, where do we find what?
Where do we find the fuller statement of what he said on the 16th?
We'll find that in it's item 1 of the core volume, my lord, at page 131.
That's the earlier statement, is it, Mr.
Which statement is that?
That is the statement that was taken on the 16th of December 2000 at 3:10 a.m. at the Dundalk
At 3:10?
Hotel at 3:10 a.m.
So that's the first time, is
That's
it?
the first one, my lord. And my lord will see on the second page of that statement, the witness describes the boys who were attacking the boy on the ground. He says they ran away, and he gives two descriptions.
One Lord Brown's looking for, I think it's on page 3, is it, Mr. Carroll?
The second statement is on page 3 of this appendix.
Yes.
My Lords will see the second statement taken at 20:40 hours on the 16th of December, where he introduces the description of the person who he says kicked the complainant in the face. He does that on the second page of the statement, which is Appendix Part 2, page 4, towards the top. He says, I saw one of the group kick the boy, complainant Sweeney, in the face with what I would describe as a rounded kick, it says, later became a roundhouse. I would describe him as 28 to 30 years of age, dark hair, which was quite long, medium build, 5'9".
No, you referred to he's been shown the photo board.
Yes.
Where do we find reference to that in the?
We'll find that at the foot of that page, my Lord, at Appendix Part 2, page 4.
Yes.
He says, I've been shown photographs, but I cannot identify anyone or recognise anyone from the photographs that I have been shown. I can identify all the persons I've mentioned with the exception of the male with the black hooded top. In the exclusion of the person with the tan jacket, Lords will see that at the first page of that statement of the 16th of December at 20:40. He commences that in the middle of the second paragraph in the bottom, where he says, one of the people involved in the fight was David Wong, who I already identified. I also identified a male in my original statement, and he gives the description, which is the tan fleece and scar on the face, and says, this male was not involved in the fight outside as far as I could see. He was involved in the initial fight inside the hotel. So it's a somewhat different position from his first statement. But the reference to the photographs, my Lord, must be photographs shown that the police thought were, or at least included, a suspect. Now, this statement was taken, of course, at the second statement was taken, of course, at 20:40 hours on the 16th of December. But within the core volume, if my Lords would go to tab 9, Lords would see that that is a production which was, in fact, a police photo board that was produced during the hearing on the appeal, where the suspect is stated there as being Paul McInnes at image number 4. But the witness who has shown this is stated as Brian Gockin. But the most, in my submission, Lord, perhaps significant feature of that is the time at which that photo board was created, which was 11:11 on the 16th of December, some 7 hours or so before Mr. Pearce was asked about the incident on that evening, and before he was in fact shown the photo board. So it does seem likely, very likely indeed, that Mr. Pearce would have been shown a photo board which included a picture of Mr. McInnes. Unfortunately, the board that was shown to Mr. Pearce was not produced, either at the trial or on appeal. But it does point to a reasonable likelihood, strong likelihood perhaps, that a board such as that with Mr. McInnes on it was shown to this witness.
Yes.
My Lord, the test that was identified and applied in McInnes does appear, at least intentionally, to have been moved away from the test that was adopted by the Privy Council in Holland, the Hogley-Clark test, which of course was common law test.
It wouldn't move very far if you just called it, if you said the possibility had to be a real possibility.
Yes, what the court indicated, and I do appreciate that the court says the test of a real risk of prejudice to the defence was rightly, in our view, adopted in Kelly, the HM advocate. Now, on having looked at Kelly, although initially in the application for leave to appeal, it was thought that the Kelly test was in fact higher. When one looks at the Kelly test, it's the same test, it just uses different languages. It's the Hogg v. Clark test. It uses a different language.
So I'm getting awfully lost. What is the correct test on your submission?
In my submission, my Lord, the test is whether the prejudice which is said to arise amounts to no more than a loss of opportunity.
Well, I better write this down. You've no doubt got it in a crisply formulated form. Can you dictate it?
Yes. The prejudice, in my submission, Lord, is a loss of opportunity to the defence. A loss of opportunity to the defence.
What am I writing down? I've written whether prejudice, but what should I write down?
The prejudice is the loss of opportunity.
Wait a minute. The prejudice is the loss of opportunity
to the defence.
To the defendant.
To point to a piece of evidence.
Point to a piece of evidence.
Or even the demeanour of a material witness in responding.
Or even the demeanour of
a material witness.
Material witness.
In responding to competent questions.
To constant questions?
To competent questions.
Competent questions.
On material issues.
I'm sorry, I rather wanted your counterpart to a real risk of prejudice to the defence.
Yes.
I mean, are you criticising that test? You ask, in respect of the failure, has that caused a real risk of prejudice to the defence? Now, do you accept that that's a correct test, or would you say it's a wrong test?
It is the correct test, my Lord, but in my submission, provided the risk of prejudice is not overstated by the court, or at least over-applied, perhaps, by the court in assessing the materiality of the information that was previously withheld. In a trial, of course, the accused need only, if anything, raise a reasonable doubt. He need not even raise it. The jury would be directed that if a doubt exists or if a doubt arises, that's sufficient for an acquittal. So, where an accused person has been denied the opportunity of pointing to a reasonable doubt because a piece of information, material information of course, and it's only material, has been denied him, then he is prejudiced. He's prejudiced at the trial stage because he can't point the jury, the fact finder, who's heard all of the evidence and seen the witnesses and observed their demeanour, he can't point to that piece of material information and say, that raises a reasonable doubt, not a speculative or fanciful doubt, but a reasonable doubt. And that could arise from a number of things, and particularly in a case involving identification, where in this particular case, identification was the only issue.
Is the test described accurately then in your case at paragraph 6, page 12? As I read it, you are making the point there that there are, as you detected, two possible tests, one setting a lower threshold than the other.
Yes.
And you're picking up what was said in Holland and pointing to the fact that it had some predecessors in earlier Scottish authority, particularly the case of Hogg against Clark. And as I read your case, you were asking us to endorse the test as set out in Hogg by Lord Justice General Clyde. Is that right?
Yes, Lord.
And so is that really the answer to Lord Brown's question, that if you wanted it succinctly put, you find it in the quotation from Hogg against Clark?
That is the answer, my Lord, but although the Crown's position is, of course, that the same test was applied in McInnes' case.
Yes.
So we have different forms of words. And as the court pointed out in McInnes, at least observed it in paragraph 20 of McInnes, the suggestion seems to be, for example, that Lord Sawn, by introducing the concept of prejudice, somehow moved away from a test that was properly applied. And the court didn't. Introducing prejudice is, of course, all well and good, provided the prejudice is properly understood. And in my submission, the prejudice to the accused must be a loss of opportunity to point to something that could raise a reasonable doubt in the trial. Because that really is his one chance before the fact finders, having heard all of the evidence, for an acquittal. That's his one chance.
Well, it could be said that that's just one step along the road to a conclusion.
Yeah.
First of all, you have to identify this being a devolution issue, that there was a breach by the Lord Advocate of the duty of disclosure.
Yes.
And that's accepted here, that the exit statements were not revealed, and therefore that breach is there. And then you have, flowing from that, the consequence of the fact that you didn't have this material was there was a loss of an opportunity to put that material to the witness at the trial.
Yeah.
But that still leaves open the question as to what the net result of that is, the end result, I should say, is. And are we not taken back to the statutory test as to whether there was a miscarriage of justice?
Well, there is, and the Advocate General for Scotland touched upon that this morning, this possible difficulty with whether it should be a miscarriage of justice or a nullity. The devolution issue, of course, raises an issue under Section 57(2), and Lord Osborne in Fraser seems to be suggesting that for so long as the incompatible act persists, the Lord Advocate can't move forward and seek a conviction. Any conviction's a nullity. Seems to be a different test than the one that might be applied for a miscarriage of justice. Because he does also indicate that in the miscarriage of justice case, what we're looking at there is a trial that was fairly improperly conducted, but for whatever reason, reading into what Lord Osborne is suggesting, the accused should not have been convicted. It turns out, perhaps with fresh evidence, he was entirely innocent. That's a miscarriage of justice. It seems to be quite a different test. What I'm saying, my Lord, is in the Section 57(2), and I'm at one with Lord Osborne on this, of course, in a Section 57(2) issue, then for so long as that breach persisted, the Lord Advocate should not have sought a conviction.
Now, I think you'll need to explain a little more what Section 57(2) is talking about. That's in the Scotland Act, isn't it?
Sorry, Section 57(2) of the Scotland Act, which is the provision which makes it unlawful for a Scottish minister, of course the Lord Advocate is a Scottish minister under the Act, to act incompatibly with the convention right.
Yes.
And the incompatible, the issue of whether an act is incompatible is something that seems to have caused some debate in Scotland, because it seems to be viewed as something that must be a breach of a convention right. Whereas, in my submission, Lord, properly understood, incompatible is simply, as Lord Clyde said is an act that's in conflict with a convention right. There may never be a breach of an actual violation, albeit there may be an attempt to breach. There may never be an actual violation, although there may be an attempt to violate an article of the convention. So an incompatible act doesn't necessarily result in a violation.
I'm getting completely lost. I mean, is it your submission that the mere non-disclosure, because that on the face of it is inconsistent with the obligation to disclose under Article 6, that is incurable by any appeal process?
The mere non-disclosure, provided it's of material information, is curable if the court applies the proper test. It is curable. I think I have to accept that, my Lord. The Strasbourg court seemed to accept that as well. It is curable, provided the proper test is applied. But in a case where the Lord Advocate is responsible for the withholding of the information, in this case, whether personally or vicariously is not relevant, but where the information is withheld by the prosecutor, the court obviously looks at whether that was material. Could it have made a difference? And if that information could have made a difference to the outcome of the trial, then the High Court should have quashed the conviction.
The only question is whether it is whether it has to be a real possibility, and
Yes.
the court assesses that. I
Yes.
don't think you really dispute it has to be a real possibility. It can't be a fanciful
Yes, it can't
or a speculative possibility. It's got to be a real possibility, or as the court put it in whatever the case is called, a real risk.
Yes.
I mean, that's it. And the question here is, I would have thought, the only question really at this stage is whether that test was satisfied here or not. And the Court of Appeal said no, and you say they misapplied it. Is that right?
Yes.
No,
And that's really what it all comes to, how we analyse paragraph 20 in the Court of Appeal's judgment, I think.
Yes.
And paragraph 21 begins with the first sentence, says, applying that test was the present appellant denied a fair trial. And if the answer to that is yes, then that would amount to a miscarriage of justice and lead to the setting aside of the conviction.
Yes.
That's the step by which they proceed. And do I understand that you would say that's the correct way to go about it, so long as the correct test is applied in following that route?
So long as the correct test is applied, the court seems to have wanted to move away from the test and adopt a higher test.
Yes.
So although the words appear similar, when we look at the way in which the court actually applied the test to the evidence in this case, where identification was an issue, and Mr. Pearce, or in relation to Mr. Pearce, there was very little required to put him over the edge and out of consideration by the jury, perhaps. They may have disregarded his evidence.
I mean, do you dispute the real risk of prejudice, Mr.?
No, I don't dispute a real risk of prejudice.
And he comes back to it, lower on the same page, 5 lines up from the bottom. The critical issue is whether non-disclosure of that information presented a real risk of prejudice to conduct of offence. So he stated it twice. You accept it's the right test, you say he misapplied it.
Misapplied.
Well, it's a fairly short point, Mr. Carroll.
Yes, ma'am.
Is there anything more you would like to show us before you finish?
So why do you say misapplied? Just as I'm clear, Mr. Carroll, I'm not quite sure I've grasped the facts well enough to know why exactly you say he's misapplied.
The words used, my Lord, obviously are clearly similar to the words used in Kelly.
Yes.
And the Kelly test, the Kelly judgment, when it's analysed, is clear. It is in tune with Hogg v. Clark, although the words are different. It is in tune with Hogg v. Clark. And in Kelly, the court did look at the evidence that had been withheld, properly analysed it in the context of the evidence that had been led at the trial, and said it would have made no difference. It was quite clear it would have made no difference. And indeed, went on to say that the Crown could have used the evidence that had been withheld and advanced its own case. So there was no realistic prospect there of raising a reasonable doubt in that trial, and therefore there was no prejudice. In the McInnes case, the court, in paragraph 20, does indicate that it seems to be unhappy with what's being said about the Hogg test, the Hogg v. Clark test. And although the court then talks about the Kelly test, saying the real test is as explained in Kelly, when the court goes on then to analyse the evidence that was not withheld, namely the uncertainty about Mr. Pearce's evidence, it then takes what I would say it's a very strict approach, which it shouldn't have taken. It takes a strict approach, pointing to, in my submission, pointing to the conclusion that the court had adopted, albeit the words are there, but had in fact adopted a different approach.
Where do you see that, Mr. Carroll?
Well, I say that, my Lord, because the evidence...
So where do you see it in the Lord Justice General's opinion? Where is, I mean, just asking whereabouts do you say that he's applying this strict approach?
He talks about the real risk of prejudice, my Lord. I have to say it on the basis of, although the words are there, and he is clearly, seems to be unhappy about what's being said about the Hogg v. Clark test. In other cases, those words have been used or abused. He's unhappy about that test. I can only say that when I look at how the court treated the evidence that had been withheld in the context of the evidence that had been withheld.
Really what you're saying, Mr. Carroll, is, having regard to the facts of the case, the only conclusion open to him, if he correctly applied the right test, was to allow your appeal. Isn't that really what you're saying?
In a manner of speaking, that's correct, my lord. I have to acknowledge that. But I wouldn't be saying that if the court had itself, if the High Court itself hadn't acknowledged in granting leave to appeal, that it may well have applied the wrong test. So although the words...
Sorry, who's acknowledged what?
Well, the court granted leave to appeal on the basis that it acknowledged that the test it had chosen to apply, or the way it had applied it, was in conflict with Hogg v. Clark and Holland.
Well, that's what was in your application, at least. We don't have a reason given by them, but you did persuade them to grant leave.
No, they didn't give a reason, my lord. What actually happened was simply that leave to appeal was granted, the court having acknowledged that the test that applied and the approach to be followed were in conflict. And the word conflict first arose in the hearing on the application for leave to appeal. The interlocutor granting leave to appeal doesn't contain the word conflict.
No. But can we go back to Lord Rodger's question? I'm looking at paragraph 22 in particular, where the court are analysing the material that was available at the trial and the material which was withheld. And what they point to is the fact that this is page 26, I think you'll find it in the appendix. Do you have that?
Yes, Lord.
And as I say, the Crown did include in the list of productions the reports of the parades, and then what was omitted was the statement taken immediately after the parade, which is the exit statement, and we see it quoted there. And then they're, I think, going on to say, well, what effect does the omission of that material have on the overall progress of the trial?
Well, counsel at the trial wasn't able to put the words of the witness to him.
Yes.
Of course, counsel had available a note that was taken within the Proctor Fiscal's office. And this was a note taken by the solicitor with the representative of the Crown seeming to read from the Crown recognition. But he wouldn't be able to put the gist of that note to a witness. He could only just cross-examine around the generality of that note. In order to attack the witness, he would require to have the witness's statement and put the words to the witness, just actually what he did say. And in the exit statement in relation to this parade, he actually referred to 406, who was not McInnes, as being the person who'd kicked.
Neither 4 nor 6 was Mr. McInnes.
Neither 4 nor 6 was the appellant. But he referred to 406 as one of them being the person who delivered the roundhouse kick that knocked the complainant to the ground and left him at the mercy of others who then attacked him. So he didn't have that exit statement. And in relation to the statement at which he made an identification by resemblance, that is the McInnes parade, he didn't, when he was coming out of that parade, give any indication of what he said McInnes did. So it left it that he may have thought it was Esdale from the 406 or the stand-in. He left it. It could have been one or t'other. But when it came to trial, counsel at the trial was effectively prevented from going down the road of cross-examining the witness on a prior inconsistent statement, because there were inconsistencies within the statement.
Well, I think the Court of Appeal appreciate that, don't they, in the last 4 lines, because what they're then doing is seeing what could be made, what could be made out of this, and yes. They're saying it tended towards the identification of somebody other than the appellant. That's one point, and then it also carried an inherent unreliability because of the way he'd expressed himself. And that's a basis for saying, well, let's give you that amount of, as it were, credit for the fact that this was withheld. It would therefore be useful material to you for those reasons. Yes. But then let's put it into the overall context. I think that's what they're doing.
That's certainly what the Crown's doing. The Crown, in this particular appeal before this court, my Lord, I think have adopted the view that but at the time of the trial, counsel chose tactically to concentrate upon clothing and body, etc. But had counsel at the trial had available the actual exit statements, and of course the information concerning photographs, because that had not initially been disclosed, then the tactic may have changed. The defence may have followed a different course of inquiry, and the tactic at trial may well have changed, because we could then direct the witness to the faces of the standards. Because at the identification parade and on photo parade, it is only a face. So we're moving away from clothing to faces. So we don't know exactly what counsel would have done, my lord, because it is unfortunate that counsel in this particular trial is now passed away. But there's a limit to how far we can second guess what counsel would have done. I think it's reasonable to suggest that counsel may well have changed tactic, particularly with the information on photo boards, prior identification, the accused being a suspect in December, whereas the Crown understood, or it was understood at the time of the appeal, until the photo boards were produced, that McInnes was never a suspect until August of 2001.
Well, would that be a convenient point at which to break? Because we're obviously not going to finish immediately. We look forward to seeing you again at 2 o'clock.